Hello and welcome to the CIArb PolicyCast, the series where we speak with leading experts in the world of dispute resolution about some of the cutting edge issues in our sector today. Today, I'm delighted to be joined by two representatives from Omni Bridgeway, the global dispute finance provider. We have Ruth Stackpool-Moore, who's the investment manager at Omni Bridgeway. Hi, Ruth.
Hi, Lewis. Thank you very much.
And we're also joined by Tom Glasgow, who's the Chief Investment Officer for the Asia region at Omni as well. Hi, Tom.
Hi, Lewis. Thanks for having us.
No problem. It's very good to be joined by you, and especially for the topic that we're going to be discussing today, which is third-party funding in dispute resolution. Now, third-party funding is one of those issues that is often misunderstood, and so I hope that today we can enlighten our viewers and maybe also provide something that will be of value for those who are already familiar with third-party funding, and perhaps even practice in the field and are familiar with it professionally. So, just to start things off. For the benefit of our viewers who may be unfamiliar with the concept, can you explain, in essence, what third-party funding is and how it works in commercial dispute resolution?
Sure. Okay. Well, in its most basic form, third-party funding is basically where an otherwise uninterested party will agree to finance the costs of a dispute in exchange for a share in the commercial benefit if the case is successful. So that might include funding lawyers' fees, court or arbitrator fees, expert witnesses, and so on. Some funders, like Omni Bridgeway, will also fund the adverse costs of the respondent if the case is unsuccessful. So that essentially removes all of the downside risk for the funded claimant. Unique to litigation finance is that it is typically done on a limited recourse or sometimes called non-recourse basis. And what that means is that we're only entitled to a share of the benefits that are actually recovered. So if the case is unsuccessful or we're unable to collect on an award, there is no liability on the funded party to pay back our investment. So in that sense, the claimant or the funded party can transfer all of that downside risk in the event of a loss. Beyond that sort of basic form, there are many variations. Sometimes we're asked to fund only a portion of the costs. Sometimes we're funding everything. Sometimes we'll fund a single case. And sometimes, indeed probably more often now, we're funding a combination or a portfolio of different cases. And that might include non-monetary claims and defences as well as claims. Sometimes businesses are really just wanting to leverage that contingent value in their claims, not just to fund the dispute, but also to fund their core business, essentially using litigation finance as a corporate finance tool.
Excellent, thank you, Tom. That's a really good thumbnail sketch, I guess, of how third-party funding works. I wondered if you could both give us a little bit of insight into your professional experience of third-party funding, maybe refer to some of the highlights of your careers and what that may have taught you about how third-party funding works in practice, and a little bit about your current roles at Omni Bridgeway.
So when you introduced us, Lewis, you mentioned that I'm an investment manager in the Singapore office. I think a lot of people know people in funding or have spoken to them at some time, but maybe don't understand exactly what it is that we do. So effectively, my role as an investment manager is really to work in a collaborative sense, both with lawyers in the sort of Singapore community and regional community, as well as colleagues throughout the world in our various offices to find cases that might be suitable for funding. So that might be us directly speaking with corporates who are interested in knowing more and then having their case assessed, or lawyers bringing cases to us where they think their clients might benefit from the use of funding. And really, so what we do is we go through an assessment process where we work with the lawyers who are involved and the clients to really understand the cases, to do a review of them, both in terms of the merits and the possible aspects for recovery at the end of the day. We put them through their paces essentially, and if we think the case is a good one, we present it to the investment committee for their view as well. And if the case is one that we would like to invest in, then we put in place a funding agreement, and that's when we really become part of the strategic team of the case as it goes ahead. So we don't manage the case in any way, that stays with the lawyers, but we do provide strategic input and help with the management of the case, really just bringing the benefit of our experience to each of the different cases that we're working on. So for myself, I've been working in funding for about 5 years now, first in Hong Kong and now in Singapore. And in terms of key moments, I think really I've enjoyed first and foremost seeing the development of funding in Asia as a whole. When I started, you know, funding was accepted in the insolvency context in a few countries, but really over the last 5 years there's been an enormous development in terms of general knowledge and allowance of funding, which has been really exciting. And on particular case-by-case basis, you mentioned already the access to justice side of things. At the moment, I'm definitely working on one of the case highlights of my career so far, which is to help an artist who's really in the midst of a David and Goliath style battle, where, you know, really the other side's strategy was just to bankrupt her essentially, and they didn't really want to engage with the merits of her claim. And so being able to step in, she'd managed for 8 years to sort of struggle on and continue to try and access justice, and was getting to the point where she couldn't keep her head above water anymore. So for us to be able to step in and help with that really is very gratifying and shows the benefits that funding can have on a more than financial scale.
Yeah, I can imagine. I think that's a really important insight into the wider context here, and that's something I want to come on to in a moment as well, about what the wider benefits of third-party funding and the function it performs. Tom, did you want to talk a little bit about your experiences as well?
Sure. I mean, I'd echo a lot of what Ruth has said there in terms of highlights of, you know, the Asia region, and those feel-good cases are fantastic to do. You know, Ruth and I are working on that one together. We've had a handful of others since I joined Omni Bridgeway, and it is nice to be able to give access to justice to those that need it. But I think what has surprised me actually is how much interest there is from well-resourced corporates in our product, and really seeing how in Asia there has been this sort of jump ahead to the sophisticated use of litigation finance that has sort of gradually evolved over time in other more developed markets like UK or Australia. You know, Asia's really sort of jumped straight into that more sophisticated understanding and use of funding, which has been interesting and certainly been a highlight for me in this region. My role as the CIO for Asia is really to manage our investment portfolio in this region and the investment team. You know, so working very close with Ruth and our other team members here, but also to look at other opportunities for growth and looking, you know, where are the markets where we can perhaps develop our funding model, in particular in the international arbitration space. So although our team's based in Singapore and Hong Kong, a lot of our work comes from around the region, and looking at, you know, which markets we need to focus on and develop to find the right sort of cases is really interesting, especially in such a sort of emerging area for our industry and indeed a lot of emerging economies as well. It's a fascinating area to be working in.
Mm-hmm. Yeah, undoubtedly. I know just how vibrant things are, particularly in Singapore, but also in the wider region at the moment, when it's just generally, but certainly when it comes to innovations in dispute resolution, they really are at the cutting edge. Just on that point, it'd be interesting to hear a little bit about how you think the framework of third-party funding has evolved in recent decades, and what you think the main trends have been.
So, I mean, it's taken leaps and bounds, as Tom said, in Asia in particular. You know, as little as 5 years ago, it was a tool used predominantly in insolvency on the access to justice front, and not a huge amount in other spaces. So I think you can look at what's happened in Asia as a bit of a sort of truncated way that it's developed in many other jurisdictions as well, particularly in the common law. You know, for many, well, for a very long time, not just decades, you know, there were these very ancient doctrines that developed from the feudal times, when lords and barons, you know, used their ability to fund other people's proceedings for their own benefit. And so, you know, that sort of led to an idea that third-party funding was a bad idea. But thankfully, in the UK, now many decades ago, that idea was surpassed, and the UK has been moving beyond that for a long time now, and also in Australia as well. But now in jurisdictions like Hong Kong and Singapore and others that had those doctrines, they've largely abandoned them, or at least modified them, such that certainly in insolvency funding is now well recognised, and also in general in litigation in many jurisdictions. That's something that we're working on here in Singapore as well. And also in arbitration, I think now it's quite well accepted that funding is here to stay, and something that is part of the arbitration landscape now. And so that's really, I think we see that in common law jurisdictions and in civil law jurisdictions where there never really was any impediment to funding. It just wasn't something that was very well known or understood. And so gradually that conversation has also come to the fore, with lawyers sort of opining on whether there is any reason why funding can't be allowed, and often the response being, well, actually, yes, it can. And so then really it's just for the funders to understand the jurisdictions in which they're going to operate, you know, what the legal framework is there, and how they can operate within that. So effectively, I think it's just a geographic spread to many more countries, and that will progress further, I think, in the years to come. And also then in terms of users, there's also been a shift as well. Initially, it was mainly just impecunious parties, or those that really couldn't afford to bring their own claims. But now, as Tom just mentioned, you know, companies really do recognise it as a type of corporate finance, where they can really leverage the value of their claims, and de-risk their ability to follow them. So I think that will only continue more as we proceed, and certainly the economic effects of the current pandemic have certainly increased that, I think, such that third-party funding is becoming a conversation that more and more people are having and wanting to understand. So I think that's probably the main developments, I think.
Yeah, thank you, Ruth. And I think given that third-party funding is now so well established, I wondered, Tom, particularly, whether you had any thoughts on, firstly, how it's perceived by arbitration practitioners and the wider public, and within that, whether there are any particular misconceptions.
Yeah, I think it's fair to say that the perception of litigation finance is evolving. You know, it may first have been viewed with some trepidation in some circles, especially in common law jurisdictions, as Ruth mentioned. You know, the medieval principles of maintenance and champerty. That sort of hangover affected a lot of the legal community, I think, in the early days of litigation finance. But that's dwindling, thankfully, because, you know, in truth, what we offer is just another form of finance, leveraging the value in an asset class that was in the past ignored. So the market is beginning to understand that now. I think there's no magic to this, really. You know, there's a better understanding of what we do, and I think, you know, those risks and concerns that were initially raised in the early days of our industry really haven't come to bear in practice. You know, so because of that, third-party funding, I think, is now generally accepted, especially in arbitration circles, as genuinely a valuable tool for providing access to justice, as well as corporate risk management and finance, and as a necessary thing to help deal with the increasing costs and complexities that arise in international commercial disputes. So I really think, whatever misconceptions may have existed or may still exist, I think we typically find that they fall away pretty quickly when practitioners actually start to engage with us, work with us, interact on a specific case and see what it's all really about.
Mm-hmm. And you mentioned access to justice there, Tom, and I wondered, Ruth, in light also of one of the examples that you cited earlier on, what role that you think third-party funding plays in improving access to justice and allowing parties who otherwise wouldn't be able to access redress to do so, and specifically what evidence you think there is to back that claim up if you think it does stand up.
I mean, I absolutely think it's one of the overarching benefits of funding if you move beyond just the sort of the corporate financing side and look at it from more of a benefit to society. And, when you look at it, the claims that we fund have to go through a rigorous due diligence process. So there must be meritorious claims. So in doing that, we are then able to provide finance to people who otherwise wouldn't be left with no recourse. And so the claim that I mentioned, the claimant had been fighting, she effectively has copyright in a number of images, and she has been trying to pursue her rights to not have those images used for 8 years, as I mentioned earlier, in the US, and then she was forced to bring proceedings here in Singapore. So she's fighting on multiple fronts. She was able to expend quite a lot of her own personal wealth. She did have to sell a lot of her property, and so she invested a lot of her own wealth in that, but eventually was getting to the point where she was no longer able to continue. And at that point, we were able to step in and help her so that she could sort of get to the finish line, I suppose, because really the respondent strategy, they knew her circumstances, and I think they understood well that if they just strung things along, they could make the claims go away without really having to engage with them on the actual merits of the claims. So it's very satisfying for her and for us to now know that that's not possible. And one of the fairly evident results of that is that the respondents are now having to engage on the merits. And after 8 years, there is looking like there will be a mediation in due course where we hope there can be some reasonable discussions. But in any case, even if that's not successful, the claimant can rest assured that she'll be able to take her claims all the way through and have them heard, which is very important to her and also to the sort of larger artistic community, I suppose. And that's just one of a number of cases where, a claimant might not have the resources except for the finance that we can provide. And so I think obviously there is a lot of merit in that service or that ability being available to members of society if they're otherwise unable. And often it's the case that a claimant is left in that circumstance because of the actions of the person that they wish to pursue. So really, it is grossly unfair that the person who's in the wrong can then rely on the lack of funds and not have to face the consequences. So I think, yes, the role that third-party funding has in able to rebalance those types of situations is really very important.
Mm-hmm. Yeah, thank you, Ruth. I think that idea of third-party funding as creating some of a level playing field or redressing the balance is a really interesting one. Just in terms of what our members and viewers might be particularly interested in here, obviously the CIArb membership represents practitioners from right across all forms of dispute resolution in many different capacities. And I wondered, Tom, if you could give a bit of an overview from your perspective of what the main issues are that practitioners or counsel should be cognizant of when dealing with a third-party funded case.
Sure. I mean, I think that topic in itself could be an entire webcast because there are so many sort of nuances and issues and things to discuss around it. But perhaps I can just highlight a couple. For arbitrators, I think it may not always be apparent that a case is being funded. And of course, where you do have another party that has a direct interest in the outcome of the award, there are potential for conflicts. Now, there's differing views on from a practical perspective, how likely a conflict is to arise. But a lot of the institutional rules now require disclosure by the parties if a funder is involved, or indeed if an insurer is involved in funding the case and has a direct interest in the outcome. But also what we're seeing is a lot of arbitrators, irrespective of the rules, ordering or asking the parties to make such a disclosure, to indicate whether they are backed by an insurer or backed by a funder. And I think that is the appropriate and the conservative approach that arbitrators should adopt to ensure that there aren't potential conflicts that could give rise to a challenge down the line. At the end of the day, they have obligations to protect the integrity of the award that they give, and I think that's an element of that. The other area is around costs, and it's really important, I think, for tribunals not to think that because a case is being funded, there is less of an incentive to award costs if the funded party is successful. Cost recovery can be a really important aspect of the overall net recovery for that successful party, even if they're funded. It's not the funder that's being compensated, it's that funded party, essentially. And that's especially important in the situation that Ruth mentioned earlier, where the claimant is impecunious, and they're impecunious because of the respondent's actions that have caused that financial distress. And indeed, in some circumstances, we're seeing tribunals actually ordering not only the recovery of legal costs, but the recovery of funding costs. So the amount that funded party has had to pay to the funder because they've been put in the situation they have by the actions of the respondents. And under most domestic legislation and arbitral rules, there is a broad discretion that the arbitrators have to make those kinds of orders. And I really think arbitrators should be encouraged to think about doing that in the appropriate circumstances, so that these claimants aren't being unfairly penalised. For counsel, there are so many things we could say about how to approach funded cases and working with funders. And perhaps I can just give one piece of advice for counsel that are looking to seek funding for their clients. Don't oversell your case. There is never a risk-free dispute, and it can be really frustrating from our perspective if we're working with counsel who just try to gloss over the issues and advocate for their case when they're presenting it for funding. You're much better off to squarely address the issues, acknowledge the case, warts and all, and explain how you think those risks and issues can be mitigated or dealt with. That way we can address them and make an informed investment decision, and frankly, you're much more likely to achieve a funding result with that kind of open approach than trying to really push the case and advocate for it when there are issues. So a bit of advice for counsel looking to seek funding, but there's more that we can talk about in this on this topic as well.
That's a really interesting point. Thank you, Tom. I think like any kind of commercial pitch, any indication that the proposal is a surefire bet would always raise alarm bells, I would imagine. So yeah, that's a really interesting point. I wanted to now ask about the impact of the pandemic. We incidentally, it's 6 months, I believe, since the lockdown was imposed here in the UK. Obviously, we've seen huge changes to how we operate and the kind of cases that are coming through. And I just wondered if what your thoughts were, Ruth, on how the pandemic has impacted third-party funding, and whether you've seen a change in the type of cases that have crossed your desk.
I think we've seen probably 4 main changes in terms of what's happening during this period. The first relates to cases that are ongoing, so they had already started before any of this, the effects of COVID were really felt. and effectively it just changed the dynamics of those who are pursuing those cases. So they may not have the funds or the ability to continue with them. So they've now thought about using third-party funding, whereas previous to that, they did not need to. Or in jurisdictions where it permits, the law firms, if they have part of or all of the risk on their books, if they're doing it on a contingency fee, likewise, they may have needed to readjust their position and involve a funder to try and have that risk allocated differently. So that's the first one. I think the second aspect of things that have changed is that some companies had awards or judgments that had been already issued in their favour, but they hadn't really thought about monetizing them or pursuing them. They just sort of stuck them in the drawer and thought, oh, we'll think about that later. Bringing in cash right now is really important. So some of those are being dusted off and brought to us to have a look at to see if we can help with any recoveries on that front, which we certainly do our best to help with. In terms of new cases that are coming up out of the COVID-19 pandemic and the different disputes that will arise out of that, we've seen some inquiries come through, not a huge amount yet. We feel like probably we're in the stage where a lot of companies are trying to resolve or really understand what their rights are at this stage, getting advice on their prospects of bringing disputes. But I think we're expecting a lot of those cases to sort of come to us probably in the next 6 to 12 months, realistically, not so much as yet. And then the fourth development, I think, really is just an accelerated interest in learning more and being educated about funding. I think it's just a conversation that far more people want to have at the moment. Businesses that otherwise would have been in a very comfortable cash position or, risk-wise just thought they never would need it, all of a sudden have realised, it's just good for them to make use of whatever tools are out there. And to monetize assets that they might not otherwise have done so, and so we can help on both of those fronts. So I think they're the four main ways that we've seen things change over the last 6 months.
Well, thank you very much, Ruth. And I think following on from that, finally, I wondered what your thoughts were on how third-party funding is likely to evolve going forward. And also whether there was any ways in which you would like the system to work better, what changes you think could be made that would make the system as a whole better and more effective.
Well, perhaps I can deal with the first part of that question, and then Ruth can answer the second. As Ruth just explained, there has been a real acceleration in the past few months, given the economic situation, in interest in funding and indeed the use of litigation funding. And I think we expect that trajectory to continue. So we've had a bit of a boost and we're on an upward trend in any event. And I think that growth will continue in existing markets and especially in international arbitration, where frankly, the costs are quite high. The upfront costs in particular in institutional arbitration can be quite high. So we think that will continue to grow. In new markets, I think we will see potential growth in other markets in Asia. We're looking closely at a number of them, but also Africa, Central and South America are likely to develop as potential markets for litigation funding. Perhaps starting with international arbitration to begin with, but then maybe moving into the domestic markets in some form or another as well. Aside from that sort of geographic spread, I think we're going to see an increasing sophistication in the funding products that are being developed, maybe trying to fund a broader range of disputes, including more defence funding. And perhaps also more prevalent use of litigation finance as just a corporate finance tool, using it to fund other elements of the business. And that's just consistent with an increasing understanding that litigation and arbitration is an asset that can be leveraged for its value. And then perhaps also we will start to see secondary markets in this area of finance. So we might see secondary sales of interests in cases. We might even see derivatives created alongside litigation and arbitration assets. And again, all as the world becomes more comfortable with this asset class and it becomes more generally understood and accepted. So there's a lot of potential interesting angles that the industry could move in, and it's going to be very interesting to see how things develop.
I think to tackle this, the second part, what might make the system work better, there's always room for improvement. I think from my own personal view, one of the ways that the system can work better is in relation to costs. Tom mentioned earlier the adverse cost risk that comes along with disputes in certain jurisdictions. Omni Bridgeway certainly takes what I think is the right view on that, in terms of, if we fund a case, we will also be held accountable for the adverse costs should the case be unsuccessful. And I do think that is something that in the circumstances is the right way to deal with that question. Funders who seek to gain rewards from cases but don't want to take on that risk, that does bring a somewhat dimmer view of the industry, and certainly can leave some respondents in difficult circumstances if they are successful but are unable to recover the costs against a claimant who might have been funded, but if there's no obligation for the funder to meet those costs. So it's just one view that I have in terms of how the industry might develop from a broader perspective in that way.
Excellent, thank you both. I think we've really been able to delve into some of the key issues involved here, and this is really what I wanted to achieve with this episode. Third-party funding is obviously sometimes quite an obscure or sometimes misunderstood field, and so I'm glad that we've been able to illuminate things for our viewers here today. So thank you ever so much for that, and thank you both for joining us.
Thank you very much, Lewis. It's been a pleasure.
Thank you very much, Lewis.
Excellent. Thank you.